Hello everyone, welcome to Civil Services Gyan. I am Prikta Srivastava. Let's start with QuiCK. So, the question for today is the phrase Audi altrum partem, recently seen in news, is related to which of the following? Now, you'll have 30 seconds to think and answer. Option A is principle of natural justice, B is equality before law, C is doctrine of basic structure, and D is doctrine of pith and substance. 10 more seconds to go. The right answer is A, principle of natural justice. Now, if you got this right, congratulations and tell me in comments and let's learn. Principle of natural justice. This is a law that is not derived from a codified source like a statute or constitution, but these are based on common laws and moral principles. So the purpose of natural justice is to ensure that faulty and retrogressive laws or their misuse does not lead to injustice. There are three main rules of natural justice. So they are: first, odi altrum partem, that is the thing that was asked in the question, and second is no one is judge in his own cause, and third is reasoned decision. Now, what is Audi altrum partem? So, according to this, no person should be punished by a court without having a fair opportunity to be heard. This has four main components. The first is issuance of notice, second is right to present the case and evidence, third is right to cross examination, and fourth is right to legal representation. This phrase or the altrum partem was recently seen in news in relation to Supreme Court's decision in case of Mohammad Rahim Ali. He was declared a foreigner by the Foreigner Tribunal, but Supreme Court overturned the decision, quoting Audi altrum partem. This rule is also known as rule of fair hearing. Now let's come to the second point. This phrase means no person should be a judge in his own case, and this rule is also known as prevention of rule of bias. The purpose is to prevent any type of bias from affecting the process of justice delivery. And what kind of biases can be there? So there can be a personal bias, which is related to one's relation with the case, like relatives and all. Second can be pecuniary basis, which is related to financial things. Third is subject matter, which is related to opinion basis. And then departmental bias, policy notion bias, and bias on account of obstinacy. Now, bias on account of obstinacy arises when a judge who was a part of the bench that gave a decision refuses to recuse from being the part of the bench that hears the appeal to that decision. So that is a bias on account of obstinacy. What is reasoned decision? So a decision that is grounded in reason and logic is called reasoned decision. What are the grounds of reasoned decision? So for first, party to the dispute has the right to know the results of inquiry and reasons behind the decision. So this decision cannot be just arbitrary. What are the reasons behind the decision? The parties should know. Second, responsibility to record the reasons is vested in quasi-judicial body, just making it accountable. Third is it acts as a satisfactory part for the party against whom the decision is made. So the aggrieved party, the one against whom the decision is made, has all the rights to know what reasons led to that decision. Second point is that adequate accountability with respect to reasonableness of the decision should be assured. Other things that are worth knowing related to natural justice: first, according to some sources, even prohibition of excessive delay is considered as a rule under natural justice. So as we have heard, justice delayed is justice denied. So a part of it is also natural justice. Now second, there are many types of principle of natural justice, two of which are major. The first is substantive and second is procedural. Now while substantive deals with the results, mainly like the results of a just judicial procedure should not be should not take unnatural course, and the procedural natural justice makes sure that the whole process that leads to a decision is moral and grounded in right law. Now, some landmark decisions, landmark cases that you can hear and can quote in answers related to natural justice. The first is Menka Gandhi versus Union of India case. This can be quoted as an example of OD Altram Parton. Second is AK Kraipak versus Union of India case. This was All India Forest Services case, and this can be used in rule of bias. And the third is Siemens Engineering and Manufacturing versus Union of India case. It was import duty case, and this can be quoted when there is a mention of reasoned decision. So that's all for today. Don't forget to subscribe. Thanks for watching. Stay tuned for more. And if I was too fast or too slow, please do drop in the comments so that I can adjust myself to your needs. Thank you for your time.